Welcome to Corporate Law Lab, a podcast from the University of Cincinnati College of Law's Corporate Law Center. I'm Neil Taylor, Director of the Center and your host. Our show dives deep into the law of business, the business of the law, and the people who make it all work. Today's guest is David Willbrand, Chief Legal Officer at Pacaso, a prop tech company transforming the way people buy and own luxury vacation homes. Before joining Pacaso, David built one of the country's most respected startup and venture capital practices as a partner at Thompson Hine. And he's also spent many years teaching startup law to students at various law schools, including ours. We're joined on this episode by Deborah Myers, one of our third years who's about to graduate, and I think this is her second or third appearance co-hosting the podcast. We'll miss her when she is at Squire Patton Boggs next year. You'll hear at the beginning of the episode that I joke with David about going to the second best school in Cambridge, Massachusetts. Since we don't record the video of our episodes, you can't see that I'm wearing an MIT hat when I joke with him about his undergrad at Harvard. In full disclosure, both my boss and my daughter have physics degrees from MIT, so I'm duty bound to pick on Harvard undergrad graduates. But yet, go Harvard. Let's get started.
All right. Go. Welcome to the podcast, David.
Thanks for having me. Great to be here.
We love having UC grads on. Let me start with, go way back. You went to, it looks like the second best school in Cambridge, Massachusetts. Is that right?
That's true. Maybe the fourth best. Depends on your perspective and your particular biases.
Well, my daughter went to MIT, so I'm honor bound to say that.
Those students worked harder. And they are smarter. So I wouldn't wrestle you on that particular issue.
Why did you decide to go to law school after that?
Lack of any other better options. I wish I had a better answer to that question, but that's the truthful answer. It's not the answer that I gave in job interviews from 1996 to 2010 until I reached a point in time where I was deep enough in my career and confident enough that I could say it out loud. But, in 1992, Bill Clinton defeated Bush 1, and he ran against a really bad economy, and that was the economy that I was graduating into. I came back to Cincinnati, got married. My wife was working in Cincinnati already. And so I looked for a job, couldn't find a job, ultimately found a job working for the Ohio Environmental Protection Agency. And my job was to climb smokestacks and monitor the testing of those particular facilities. It was a bad job. It was an outdoor job at the top of smokestacks in January in Cincinnati, Ohio. For anyone who's familiar with the upper Midwest, that's not exactly Naples, Florida. And after a couple of bouts in that particular gig, I realized this is not what I should be doing with my life. I've got to figure out something else to do. I didn't know anybody who was in business, which is ironic given where life took me. I come from a family of farmers, professionals, and teachers. So that was sort of what I knew and what I had been surrounded by growing up and what I was comfortable with. So business felt out. It just felt like a black box. I didn't have the prereqs to go to medical school, and so that left law school by default. It's a reason why a lot of people go to law school. It's a terrible reason to go to law school, but I'm just very, very fortunate that it ended up working out for me.
But having one of those awful jobs, I think, stays with you in a number of ways. The rest, I worked at Eicholt's Farm Market in the summers, and there is nothing I've ever done anywhere else that's worse than carrying an 80-pound bushel of acorn squash through the mud. So it's like you have those kind of experiences, and no matter how hard you work in the law, it's never going to be like climbing a smokestack in January, right?
No, that's 100% too, 100% right. And the other point that I would add to that, and that it's a point that I share with people, is I do feel grateful that I had such a bad job, and was having such a terrible experience that it forced me to make some moves. You know, I was at a stage where I was fairly rudderless, and was so uncertain. I was a little bit paralyzed by that. And I think if my job had been, let's call it a lukewarm job, like not great but not bad, I very easily could have floated along. Woke up when I was 40 and realized, what have I done? I've just been in this weird middle place for the last 20 years. I'm not doing what I want to do, but was never really forced to make a decision. It forced me to make a decision, and it worked out. And for that, I'm grateful.
Yeah, it's very easy to get in a comfortable rut,
Right.
especially when you're young and uncertain about what you want to do.
Yep.
When you joined law school, this may be a stupid question, but did you have any idea of what kind of lawyer you wanted to be?
Not really. I was when I went to law school, it had I was coming from the Ohio EPA, so my first thought was environmental law. That was in the back of my head. I didn't necessarily have a passion for it, but it just felt like a natural, logical transition. I found out very quickly, though, that most law firms that have environmental law practices like those lawyers to have more of a technical background and engineering background. It's not one of those things that has to be, but it's a preference. And I certainly did not have that. I was a history major in college. That's a long ways from a technical background. And so, given the fact that I didn't have this hyper passion for it and wasn't prepared to push that boulder hard up that hill to persuade them that I could overcome that particular need or desire or preference, I started to look in different directions. I took Professor Murphy's labor law class and loved it. So thought labor law might be my calling. Had a summer clerkship at what was then Frost and Jacobs. Now it's Frost Brown Todd. I don't know what the situation is today, but in the mid 90s, they had a very strong labor law practice. But what I noticed, and this was starting to happen in the field at the time, labor law and employment law were converging and were becoming labor and employment law. They were no longer really treated as two separate disciplines. And labor was not union management for the most part. Labor was really leaning very hard in an employment law direction, an HR perspective, in that sort of a direction. And that wasn't as appealing to me. Now, look, some of my best friends are employment lawyers, so this is not, I'm not throwing shade. It's a great practice area, but it wasn't really what I wanted to do. I was more interested in the labor side, and that was shrinking in America. Whether you're on the management side or the union side, collective bargaining is just not what it used to be. And so, a shrinking market is not really one that you necessarily want to gravitate toward. I ended up in corporate law somewhat serendipitously. During that summer clerkship at Frost, I happened to be placed on the corporate law floor. So you know how law firms work. They're like Neapolitan ice cream. You've got the different practice areas at the different levels. And I was at the chocolate level. That was corporate, the corporate group. My office was next to a fourth, fifth year associate who gave me a lot of work, and she was great and really convinced me that corporate law was a viable path. Again, I had this nervousness about business, and corporate law, in its name, interacts with business. And so I was a little hesitant, but she helped me get through and over that, and that's where I landed.
What did you do when you graduated?
So I joined Frost, and I joined Frost in 1996. I joined the corporate law group. So, you're a baby associate, you're in the corporate law group. So you're doing some of everything. You're doing commercial contracts, you're working on some banking deals, you're doing some debt deals, you're doing some small business work, some real estate work, some public securities work, a broad base of different issues, different matters, different types of clients, different types of corporate law. But what started to emerge pretty quickly was, 1996 was the beginning of the dot-com bubble. And I always say that the internet democratized opportunity and access, but it also democratized the geographic dispersion of startup companies. Before 1996, you were really talking about the Bay Area and Boston. And those two markets certainly still remain hyper concentrated when it comes to startups and founders and entrepreneurs and VCs and so on and so forth. But the internet allowed more people to connect to that world. And you were finding, even in places like Cincinnati, Ohio, that startups were beginning to emerge. No one else in the firm was really doing it. There were two partners in the firm who were getting this work just by virtue of prior relationships They didn't have any associates who wanted to work on it because those associates were in their groove, doing M&A, doing public securities, doing banking work, whatever that specialty was. I was a free agent. I had the fear of God beaten into me because of my experience in 1992, having had difficulty finding a job. And I said, sure, I'll do the work. I just want to stay employed. The good news was I ended up falling in love with it. And 30 years later, here I am still in the middle of it.
Great. And then you went in-house, then back to the firm, then back in-house, right?
There was a little bit of a dance with a move to Boulder, Colorado thrown in there as well, just to keep
Right.
things interesting.
So what went on there when you first went in-house? Was that a lifestyle choice, a startup that just had to be joined?
Yeah, great question. I would say that so I moved to Boulder in 1997, really following the internet bubble. So certainly I had been given a tremendous opportunity in Cincinnati, Ohio, but Boulder was one of those communities where the mass was growing more rapidly. And so I wanted to participate in that. So moved there, joined a firm there, just continued to develop my skills, get more experiences. And at the time, it was a lifestyle choice too, just to have the opportunity to get outdoors and enjoy the mountains. But my family grew. We had a child out there, and then as these things often go, returning to your roots becomes more attractive than simply going on a hike now and then. So we returned to Cincinnati in 2000, and during that period, I had been working with startups and was starting to get the bug myself. You if you're around entrepreneurs enough, it's contagious. And I was fully contaminated. And so when I returned to Cincinnati, it was an opportunity to say, you know what, maybe I'm making a literal physical shift. Maybe it's a time for me to make a professional shift too. And so I joined one of my clients, a client that I had a great relationship with. Interestingly enough, I mean, this was 2000. They were based in New York and Ottawa. I was in Boulder and then Cincinnati. I was working remotely 25 years ago, before we really had the tools that we have now. It was a very different experience. I can say that, and we can talk about that more if you want. Um, but it was, I would say, it was a mixed bag in terms of making that leap. Number one, I did it in March of 2000, which was the .com peak. So I left at it's literally buying at the top of the market, which is not what you want to do. So the first company that I joined really struggled. I mean, it was a classic .com, and when the air started to leave the bubble, um, we really struggled. And I went for several months without getting paid, and I just couldn't do that. I was 30, I had a family, I didn't have the kind of resources to support a life without an income. So I left and transitioned out of that job, helping them manage basically a sale into a larger company that was fine. It wasn't a great outcome, but at least people landed on their feet. And then I joined a company in Cincinnati called Blue Spring Software, which we would call now a B2B SaaS company. At the time, we didn't have any of those words or acronyms, but that's what it was. I was there for 3 years. And I was in the GC spot. We too, really fought through a very difficult economy. We pivoted several times. We had to restructure our business model in pretty fundamental ways. I took on a lot of extra jobs while I was there. So I came in as the GC. I ended up being the chief administrative officer, which is a really fancy title for someone, in particularly at an early stage startup, who just does everything that the CEO and the CTO doesn't want to do.
Yeah.
So some of it's heady. I had a ton of board exposure. I worked very closely with the core investors and the VCs, which was great. I was pretty active on the business development front and the business model front, development, elaboration, exploration, communication. But I was also responsible when the dishwasher didn't work. I locked and unlocked the doors. If there was a paper jam, people were mad at me. We had a popcorn machine that had to be operative at 4 p.m. because people were very committed to their popcorn. That was also my job. So it was sort of a ones and zeros kind of situation, broad spectrum.
That sounds like fun, was it?
Yes and no. It was. I wouldn't trade those 3 years for the world because I developed some skills that I've been able to leverage in meaningful ways across my career. It was very much for me, it was one of those definitional moments. It really was a chrysalis, and I really emerged just a better professional with deeper perspectives and more experience and an ability to think about problems in very dimensional ways and work very closely with business people and help business people understand what those problems are and where the legal issues arise, where the risks are, and how to navigate through that and think of them more as business opportunities than simply challenges or problems. I don't think I would be able to speak to those issues or work with those issues had I not had that experience. But it was a struggling company. I people ask me all the time, how many times have you raised money? And I'll say I've raised money over 1,000 times, and they look at me like I'm crazy. But the fact of the matter is that we were on our VCs put us on a drip. They would give us money every 2 weeks, and every 2 weeks we had to go sing for our supper and basically say to them, today's Monday, payroll is on Wednesday. We need X amount of money in the next 48 hours. Here's the progress we've made in the last 2 weeks. Please fund us. And they did that for 3 years. That is a very, very, very grueling life. It's very stressful. It's very hard, and particularly when the business was. I mean, it wasn't like we wouldn't have been in that situation had the business been performing better. So obviously, that was part and parcel with a business that was really fighting to survive and looking for its reason to be. So it was very, very challenging existentially. So I would say, let me put it this way: I do not want to do that again, but I'm really glad I did
Yeah, I mean, I
once.
think for me, when I went from large law firm to large corporate to startup, just that I really enjoyed the change of mindset to there's something that needs to be done, let's do it, as opposed to, let's have a meeting about the meeting that we need to have about the meeting where we'll decide it, which was, in a large corporate, I was at a, Fortune 500 distributor of electronics. And, we used to say that when the executive board decided something, you had 50 people left to convince. And it was just so refreshing to go into a startup after that and just be like, okay, we need to change things, so let's change them.
Yeah.
On the other hand, you are constantly singing for your supper with your investors. You've said VC a couple of times. I thought it'd be interesting just to kind of demystify some of it for our listeners, many of whom are law students and young professionals. You hear words like angel VC, PE, hedge fund. Can you have a short primer on what we're talking about when we say all that, and what's the difference, and are there any firm lines between them?
Yeah, I've been teaching law school classes, as you know, on startups and venture capital for 15 years. And I always start the semester saying, I'll give you some points of interest or different rules of the road and barriers, but there's no pristine definition, as you know. But it is more of a sense of how do you think about it and in what frame are you viewing it? So I think at a very high level, there is there's a group called private equity, and those are funds that tend to invest in private companies, not public companies, although they sometimes do, and that's your first place of ambiguity. But their focus is investing in privately held companies, which of course is contrasted with publicly traded companies. Then within private equity, it further breaks down, and you'll have hedge funds, you'll have private equity funds, which is confusing because you're talking about a private equity category, but the subgroup called private equity, which is something different. They tend to buy companies, and they tend to buy companies that are already operating and doing things and have stuff, resources, assets, legacy, etc. And then you've got this column over here called venture capital. So these are firms, these are funds that pool other people's money. They put it into a limited partnership, and they seek to deploy it in big opportunities. And those opportunities tend to be grounded in technology or biotechnology, and they tend to be very much focused on market disruption. The idea is they're taking big bets and big swings. They're going to have lots of zeros, lots of strikeouts. But the hope is that across their portfolio, they will ultimately invest in 1, 2, 3, 7, 10 breakout companies. Those companies explode, do very, very well, and cover the other losses and then some, allow those venture capitalists to provide a return to their investors. And then hopefully, if those VCs want to do this as a career, it puts them in a place to raise the next fund and rinse and repeat. So it tends to be very much focused on technology. It tends to be very much focused on innovation, tends to be very much focused on disruption. And they're investing in young, new startup companies and founders who are doing that work. It's not because they have a love of technology or they're dedicated to innovation or they see themselves as economic engines. They, of course, are, but those are byproducts. Those are happy coincidences. They're in it to make money. And that's just the particular group, the particular market focus that they have.
So when a VC has a breakout, um, they are trying to take money off the table. Like that's one of the first things they're going to do, and that's where you end up in. I remember going to a large PE fund, whose name starts with black, and we were trying to raise money, and they said, "Oh, you're only trying to raise 150 million in total? Well, our minimum ticket size is 200 million. Come back in a few years." Those are not. They may have a VC arm somewhere in the building, but 200 million tickets is not a true startup, right?
Correct.
Um,
Yeah. Yep.
Go ahead. I'm just like, because you end up, for me, when I was dealing with private equity, I kind of like parachuted in high up where there wasn't very much air. We had a couple of different private equity firms who had invested in our company, and we had $450 million to spend. And that's not normal for a startup, but we were engaged in a land grab in the tower industry in Africa. So it was like, oh, here, you're going to need this much. You'll be coming back for more in a few years. And that was a totally different experience than, struggling with a VC who is making, these guys weren't making a million different $450 million bets.
Right.
This was the biggest investment that some of them had.
That's
Um,
right.
Deborah, I think you are, this is probably a good point for you to break in with the questions we talked about.
Sounds good. David, I'm curious. You've worked with hundreds of founders, investors, lawyers. What do you think separates the lawyers who really get it in the startup space from those who don't?
It's a good, it's a good question. It's one I can answer more freely now that I'm in house and I'm not in private practice. Because when I was in private practice, I would have seen those other lawyers as competition, so I would have said terrible things about them. Um, but because that's just who I am, and now you know a little something about David Willbrand and how dark my soul really is. So, which I'm only half kidding. I would say this. I think you can tackle that question from a couple different perspectives, and it's a good one. Here's the easiest way to access it is: do you lead with yes or do you lead with no? It's very simple, but if you want to be in the top 5% of lawyers, lead with yes. No matter how nutty, no matter how wild, no matter how risky an issue, problem, opportunity, challenge that a client presents to you, don't start with, no, you can't do it because XYZ. And you're so wired to do that. Part of it is because, the genotype of people that go to law school sort of tend in that direction anyway. But law school training is really about issue spotting and identifying risk. So you've spent 3 years in this hothouse developing this skill. So it's natural that it becomes your instinct. I mean, now that's your phenotype. And so you're going to have to overcome your programming, but overcome your programming in such a way to say, yes, okay, tell me more. Okay, What are you really trying to achieve? Okay, how does this fit into the larger business? And what you may find is through that conversation, just by asking questions, they talk themselves out of it, or they talk their way into a better way of doing it. Or you get to the end and you say, you can do it, but here are the risks. ABC. I'm not telling you can't, but you just need to go in eyes wide open. And if one of those risks is you might go to jail, then maybe we should talk a little bit more about how we modify this approach and think about ways to avoid that particular risk. But that doesn't come up very often. But the point is, lead with yes. So that's an easy one. That's very easy. The next level piece of advice that I would give is that I think, particularly for business lawyers, corporate lawyers, it's important to understand that when you've been activated, when you've been engaged, it's because the parties actually want to complete this transaction. They're not looking for you to make it harder. That's not what they want. If you do make it harder, you better have a good substantive reason for making it harder and understand how you're going to get beyond that. So I used to approach transactions like many young lawyers did, which was, I would show my intelligence and the level of attention that I was paying to this deal by virtue of the amount of markups that I applied to someone's draft purchase agreement or whatever, which is completely wrong. That's not the way your value is ascribed or described or understood by anyone. So don't think that way. Um, Instead, really focus on materiality, understand what's important, try to address issues verbally if you can, outside of what can feel humiliating when you throw a heavily marked up document over the transom to the lawyer on the other side. Just always have the mindset of, I'm trying to get this closed. I was hired to close this deal. I was hired to get this done. If I identify problems along the way, it's my job to fix them, not just to take them back to the client and say, oh, this is a mess. You shouldn't do this. Now, that happens sometimes. I have certainly been in cases and situations where I've come back to the client and said, look, I feel like everybody's got deal fever, which is a thing. Like, you're way down the path. This is exciting. It's fun. It's got momentum. You feel committed to it. You feel invested in it. But to say you haven't closed yet, and look, you're the ultimate decision maker. But I will tell you, based on what we've teased out and learned through this process, and what I've learned over my career, whether it was 2 years or 20 years or 30 years, is that this does not feel like a good transaction for you. My counsel is, don't proceed. Now, if you want to proceed, I'm happy to help. I will do that. But I just feel like I should say that and flash that yellow light. That's super rare. I've probably done that. I've worked on thousands of transactions. I've probably done that 10 times in my career. So it doesn't happen very often, but it certainly shouldn't happen hundreds of times. But lots of lawyers do have it happen hundreds
David,
of times.
when that happens, is it ordinarily a legal issue, or that the business terms have morphed into something that's become more unattractive for your client than what they were originally looking at?
Yeah, it's a really good question. Often the latter. So, the term sheet represents, the way these things go, of course, conversations between the parties. They think they've got a deal. So they say, okay, let's just create this high level, non binding term sheet, simply to put on paper what we think our meeting of the minds is, to ensure that we have alignment before we take the next step of truly activating the lawyers and truly going whole hog into this thing and developing whatever raft of definitive enforceable legal contracts that we need to build. And so the term sheet, oftentimes people believe, well, that's the end. Now the definitive documents just implement precisely what's in the term sheet. Sometimes that happens, but oftentimes what happens is developing those contracts as a process. People learn things, they think of things, they imagine things, they discover things, and the deal changes. So to your point, sometimes it happens incrementally in these small changes, and then it's up to you as the lawyer to say, hey, look, each one of these changes alone, not a big deal, but we've now had 12 changes. Cumulatively, you're in a very different spot than you were when we started. We really need to rethink whether this is the right thing to do. Those are the business term changes that you're talking about. And part of what you can do as a lawyer, you've got a certain distance from it that the deal participants may not have. They can lose the forest for the trees. But what does sometimes happen, particularly with small deals or deals that are where there isn't a lot of juice floating around, you're really trying to squeeze this into a narrow aperture. You can identify legal risks that you can point to and say, oof. Like I was on the wrong end of one of those once, where I was representing a company trying to sell, and buyer's counsel identified that, and I won't get into the details, but my client had some pretty significant potential legal exposure in a couple of different spots. Wasn't my fault. I want to be clear about that. And it wasn't his fault either, by the way. It was an easy oversight to make when you're trying to build a company and you don't have the resources to operate pristinely across the board. But that particular company identified that as a particular or potential issue for them, and they decided to pass. And it was probably the right decision because it wasn't a very big transaction. It was a nice to have, not a have to have. And with that kind of potential looming risk, that lawyer looked at it, went to his client, and said, "I don't think you should proceed." And I was disappointed, and my client was disappointed. But honestly, 4 steps back, it was the right advice.
That is, I think that's great advice. And even as you're explaining, lead with yes, I'm thinking about my gut reaction, a 3L student in law school, and our tendency is to jump to the issue spotting, the caveats, the it depends. But that's going to stick in my mind now, that lead with yes. My next question, what is something small that you think law students can do now that will pay off in 5 years?
Oh, I love that question. So, network, 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 network. But I'll give you some tips because I know at 80,000 feet that sounds super intimidating. So, what the basic advice that I try to give the lawyers is to play for 40. And what I mean by that is that by the time you're 40, ideally you've come to rest in a spot where you're prepared now to really knock down some opportunities. And the reason for that is that law school sets you up to be successful, but there's still work to be done. You need to develop your skill set. And, the Malcolm Gladwellian 10,000 hours has been attacked from lots of different perspectives, but I think in the law it holds. Um, 10,000 hours is, roughly speaking, 2,000 hours a year for 5 years. That's about right. You really start to understand and learn your trade, moving from theory to actually like making horseshoes, which is what we do. It takes 5 or 6 years. So, you graduate from law school when you're 26, 27, 28. That puts you in your mid 30s. Now you've got the basic skills. Now you're in a position to really spend some period of time implementing them. By the time you're 40, you should be pretty proficient. That's number one. You don't have anything to sell if you're a crummy lawyer. So, I just got a nice little blip on my screen. It loved my thumbs up. It gave me an emoji there. Um, I'm a big fan of emojis. It's my second language. So that's number one. Develop your skill, and 40 is a good benchmark. 40 also gives you some time to make some mistakes. It gives you the opportunity to try some things like I did. I had a couple of cul-de-sacs. We talked about those earlier in this pod about, when I found myself at a startup that didn't work, or there was a geography that I pivoted from. 40 is not a tight time frame. You've got some room to try some different things and reset and recover if something doesn't work out. That's number one. Number two, from a networking perspective, here's what's really important. No matter how good you are, you ultimately are looking to someone to hire you. Okay. And those people are decision makers. And generally speaking, they are going to be your peers. And your peers are not going to be in a position of decision making authority until they are over 40. So you can develop these connections with these young professionals who, like you, are 27, 28, 30, 32, 33. They're doing great. They're climbing the ladder at Procter and Gamble. They're developing their skill set inside of Goldman Sachs. They're getting positioned at Google. They're doing all these things, but they have junior roles. They have middle management roles. They're not hiring lawyers yet. But when they're 40, they may start. When they're 45, yes, they will be. And so you nurture those relationships through your late 20s, through your 30s, into your 40s. And then now at 42, you have all the pieces. You have the decision makers in your saddlebag, and you've got the skills that they require. And now you're ready to really start making some real money. as a lawyer. And, because that's a byproduct of you now really starting to develop a practice. Now, how do you start networking? And the easiest way in the world is LinkedIn. So easy. So, make sure you're on LinkedIn. Find people that you are interested in on LinkedIn, people that you want to develop, that you want to get to know, that you want to meet, that you're interested in, that you can learn from, whatever. Like their posts. Okay. I'm a very active LinkedIn user. I have been for over 10 years. I pay attention. I know who likes my posts. People like me who post a lot, part of the reason we do so is because we're thirsty and narcissistic. We pay attention to that stuff, right? So weaponize that and use that against, empty, shallow people like me. And so, first of all, you become known to them. They see you. So over time, that will give you not you don't do the one, the one hit comment, the immediate connection, and hit them up in a DM to have lunch. Like what? But over time, 1 year, 2 years, 3 years. Now you've got a basis. Now you've got a foundation. You actually have a relationship. It's a weird relationship, but it's the way we operate in this epic that we're in. You have a basis to reach out to them. Number one. Number two, what can start to happen, and give yourself time, pace it, years. So spend the first 5 years just liking posts. Then now you've been on LinkedIn long enough. You've got a sense as to how it works. So now start to develop your voice. And the easiest way to do that is just by commenting. Now you've really upped your game. Now people like me who are posting a lot are seeing you show up in our comments. We like that. You're engaging with our posts. You're engaging with our content. You're engaging with us. And it can be really small stuff, just small observations. Don't be throwing heat out there. Don't be like doing these flare comments. Keep it professional. Think about LinkedIn as the office. But just start making comments. Do that for 5 years. Okay. And then now we're 10 years into LinkedIn. You're still just in your 30s, but you've now like created this momentum. And by then, I promise you, 10 years into this, you're going to be into a place where now you can start developing content. It's just going to happen organically. And by this point, you'll have some momentum, you'll have some motion, you'll have some understanding. Your brain will start to wire and think this way. You'll have things that you can share, start to post. And now you become perceived as a leader, and you're building your personal brand. And one of the things I like about LinkedIn, and the reason I was an early adopter and I've stuck with it, is one of the things as a business lawyer, particularly someone who does transactional work, and particularly the sort of transactional work that only arises every couple of years. The question, because people aren't raising money every day, they tend to raise money every 18 to 24 months. So how do I stay top of mind with them when they're not raising? Well, LinkedIn gives me a way to do it. In the past, you were stuck just periodically taking them out to breakfast and lunch and dinner. Still do that, but that's very intermittent. You can't do that every week, or you start to look like a stalker. But with LinkedIn, I can be in front of them every day, so they remember me. I stay top of mind. So when something comes up, they don't fall in love with the competition. They know to call me.
That's great. And what I'm hearing is one, play the law game, two, stay consistent, and three, get on LinkedIn, start hitting the likes, and then build your way up to the comments and eventually the posting. That's
Yes,
great.
that was much more efficiently put. Exactly right.
Well, and when you say network, I think a lot of people, they both misunderstand it and it feels icky, and to use a technical term, right? It's like, oh, do I really have to go to this quote networking breakfast and measure my success about whether or not I've walked out with 10 business cards, and force my way into conversations that I didn't feel like I belonged in, and I think, for me, it's really much more about building and maintaining relationships over time. And doing small things, right? You don't have to, when you meet David Willbrand, say, "Oh, we're now connected on LinkedIn. Let's have coffee tomorrow." Like, I always joke with people. My kids. There was a book called "Are You My Mother?" where the bird gets lost and goes around and asks the whole town, "Are you my mother?" I see young lawyers doing that in terms of, "Are you my mentor?" Just kind of wandering from person to person, going, "Can you be my mentor? Are you going to be my mentor? How do I become one of you?" And instead of doing that, just engage with them like they're another human being, because they are. And if you just keep that in mind, and that you're building relationships over the long term, I think then networking becomes, you start to see the positive of it, as opposed to it being just a purely transactional thing, because it's not. If you're doing it purely transactional, it's unlikely to work for
Yeah, I agree with that. It is 100% about relationships, and there's a happy byproduct that emerges from that if you're really committed to it and you stick with it. And this is what's happened for me: is it's where ultimately over time your friendships develop, which is perfectly natural because you're talking with people with a lot of common interests. You know, you're talking with people that are working in a similar field, in a similar place, with similar technologies, with a similar network. Fill in the blank. And that's a that's very fecund territory for a friendship to develop. So ultimately you end up in a place where your clients are your friends and your friends are your clients, or even if they're not your clients, they're friends that are sort of around the ecosystem that you're operating in. And that's great. It makes it fun to come to work. You're not working and engaging and interacting with strangers. There's a real emotional level of engagement and connection there, which is really rewarding.
Yeah, and then when you have those conversations that are, human conversations, you can find out things like, it was interesting you were saying earlier. When I came to law school, I thought I wanted to be an environmental lawyer. Save the polar bears, baby seals, and discovered fairly quickly that it was largely administrative law, which didn't seem as much fun to me. Then I took John Murphy's class and was like, I'm going to be a labor lawyer. Then I, worked downtown at a labor firm and discovered that I didn't enjoy that as much, and then, fell into being a litigator, which morphed into being something else. But, it's through telling those stories to each other and having those conversations that you find common interests that you can build a relationship on, rather than just, you have something I want, can I have it?
Yeah, I agree. I agree. And your point on mentorship is really well taken too. My wife is a lawyer also. She was very fortunate that she did have what you would call like straight out of central casting, a mentor who was just absolutely transformationally important to her. And it was her life was utterly changed by it, and the trajectory pushed up and to the right in a very dramatic way because of his involvement with her and the mentorship, simply put, that he provided her over a period of years. That's super rare. I never had a relationship like that. I would have liked it, but I never had a relationship like that. That being said, I quilted together, I would say, if I were to sit down and make a list, I would, over the course of 30 years, let's call it 10 people who provided me with valuable insight and tutoring and mentorship, lowercase m, not in a way that was explicit. I never asked. And by the way, people ask me, and to the point that you made, you're right. Because the problem with being on the receiving end like that is it feels like work. Like now it feels like I've got to be responsible for you. And I'm busy. Like I like you, but I don't know if I want to take that on because that's going to come with like guilt and obligation and commitment. And I'm just not down for that. But if you don't use the M word and you just say, hey, can we just like touch base every once in a while? And if I have a problem or question, can I bounce it off of you? Of course. I mean, yeah, 19 people out of 20 are going to say absolutely, like not a problem.
Right.
So, you can, if you get lucky enough to find one, if that serendipity happens, great, take advantage of it. But if you don't have that one singular figure, you can patch it together like I have. You just need to do so with some level of finesse and subtlety.
That's- All right, David, can you finish this sentence for me? If you're a law student thinking about working with startups, you should absolutely fill in the blank.
Don't. No, I'm just kidding. That's terrible. I think. Okay, so it's a very good question, and I like to start this by saying I'm not one of those lawyers at all who, when people come to me and they say they want to go to law school, and I say, "Oh, what a terrible idea! Don't do that." There's so many other things you can or should do. I love the practice of law. I love being a lawyer. I'm so glad that I'm a lawyer, and I love working with startups, and I'm so glad that I work with startups. But you have to do it for the right reasons. So reason number one is I find that a lot of people are attracted to working with startups because they think it's sexy. They think it's cool, because you get to wear a hoodie instead of a sport coat, and as a consequence, that's the kind of work they want to do. Um, there's no question there's a certain sizzle associated with that. I mean, if I said I was doing a deal with Google, people are interested in that, as opposed to doing a deal with a no name old school Rust Belt manufacturing company, which by the way is also really important to our economy, but people don't know who it is, and it just doesn't have the same vibe. Um, but that being said, it's like so many things in life. Like that little surface fizz lasts for about 10 minutes. And then at the end of the day, it's just work. So you better like the work. Um, and and we will get into that in a moment. So yeah, think about that little buzziness as a nice little that as an effervescent byproduct, but that can't be your reason to do it. It shouldn't be the reason to do it. Number one. Number two, there are easier ways to make money in the practice of law. It is not. There are a lot of people who have died on the beach of representing or trying to represent startups. Startups don't have any money. So the only way this practice works is if you can figure out ways to acquire revenue from other sources or more broadly. So number one, one way I did it was by having some institutional clients, in particular venture capital clients. So while I was supporting these poor startups, I was doing deals for VC funds, and those deals paid. So that was my working capital. Not everybody has that opportunity. There aren't always VC funds in every community. There aren't always VC funds that are willing to work with you. That was a really important pillar to my practice. Um, and if it doesn't exist, it makes this work very challenging. On the startup side, you need a lot of startups. A lot go out of business. It's not that different from the way VCs measure success and obtain success. You need a lot of shots on goal, and so you're going to have a lot of startups go out of business who are going to leave you with unpaid bills. You're going to have a lot of startups that where they need work and you want to do the work for them because it keeps them going, but they don't have the money to pay you, so you have to extend them that credit, and you or your law firm needs to be comfortable with that. It's a really challenging practice, and then over time, it also doesn't necessarily offer the same opportunities to slide into in-house roles, at the same level and at the same compensation level that you might find in other practice areas. So I think sometimes people want to work with startups not just because they're sexy and sizzly, but because they think they're going to get rich. No. If you are looking to maximize your professional income opportunity as a corporate lawyer, you know, public company practice is the way to go, man. Because it's good steady work inside the law firm, and then over time you're going to have in-house opportunities where you're going to slide over there, you're going to make a good base, you're going to have bonus, you're going to have equity opportunities. It's more stable, and it's more lucrative. Yes, occasionally you get to be the startup company lawyer that got lucky and joined Facebook early and became a billionaire, but that's so super rare, as to be off the chart. So you have to want to do the work. You have to like the work. You have to want to engage it, and you have to understand that you're also potentially making, a compensation decision that you've got to live with and be comfortable with. I did, and some of that I knew at the time. At other moments, I had other off ramp opportunities where I discovered this and learned it, and said, "I'm okay with that." I like this work so much, and I like the people that I do it with so much. I'm okay to make that sacrifice and make that decision. But it's a decision, and you make your bed. You gotta sleep in it.
Yeah, I think a lot of a lot of business side lawyers don't realize that in some senses they're doing contingent fee work. I
Exactly. That's
remember
a
when I
great way to
was
put
at
it.
Lewis and
Yep.
Roca and we represented the Phoenix Suns, which sounds very, very sexy. But the partner that had that work, explained that when his client wanted to buy the Suns, he put a year and a half of work into that transaction, which was a contingent fee transaction. If he didn't get the funding, he wasn't buying the Suns, and the guy had no money outside of getting the funding to buy the Suns to actually pay his bills. So at the end of the day, everybody was like, "Oh wow, Jay, that's amazing. You're a sports lawyer. That's what I want to be." Um, and he had to explain like, "No, I'm a contingent fee lawyer who had one hit." You know. Go ahead, Deborah. You had another
Oh,
question.
I was just going to say, I think there are going to be a lot of law students and lawyers who hear your explanation of, the pros and cons of working with startups. And that's going to hit home because I think, yes, it can be glamorous, but as you said, there are trade-offs there too. And I'm glad you highlighted those.
Can you talk a little bit about what the pressure points are of dealing with startups and founders who may have an amazing idea and not a lot of everybody lacks different things, right? Sometimes they lack business acumen. Sometimes they are terribly disorganized. Um, Sometimes they, have a vision that they are so wedded to that they can't see when when an opportunity has morphed into something else. Um, Enough about me.
They can be challenging characters, and it's a very good question to ask. So, I think it's a distinction that I think is important to draw. And this is another one of those that doesn't, it's like venture capital. It doesn't lend itself to a chemical definition, but it's, what's a startup? So the way I think about it is I think about startups as compared with small businesses. So small businesses, and these are generalizations, they're just useful heuristics, but they get to the point that you're driving. Small businesses, for the most part, are focused on profit, and these are businesses that are replicating pre-existing business models. They're just trying to do it better. So a law firm, a dry cleaner, a McDonald's franchise, whatever. They're not recreating the wheel. They're taking a business model. They're taking an existing market. They're taking an existing customer base. They're taking an existing product that's known, that exists, sometimes for hundreds of years, and they're just looking for a better way to do it and to do it profitably. And those are great businesses. That's 99.99% of businesses. Thank God for small businesses. I mean, it is the pumping heart of the US economy and frankly the global economy. So, no casting no aspersions on small businesses. I spend a lot of money with small businesses, and we all do. Um, Startups are different. The idea with a startup is you're literally trying to create something new. You're conjuring something up in a way that doesn't exist. It's not completely without precedent. I mean, you just don't imagine something that's a blast from another universe. You are standing on the shoulders of pre-existing technology and pre-existing products, but you're thinking about it differently and you're presenting it differently. That's what innovation is. That's what disruption is. To do that, to be the sort of person who can see that next step, who can believe that they're the person to carry this opportunity to that next step, to be that innovator, to evangelize the world and promote and sell this, you have to have you have to operate with a reality distortion field, because it's not a normal human. We didn't survive over the course of the last, depending upon how you look at our species, the last 250,000 years or the last 10 million years, by taking wild risks. Okay? Wild risks got you eaten or dead. So we tend to be, we know we need to stretch. Dopamine pushes us to stretch, but stretch within certain knowable bounds, because otherwise you die. We have here founders who are willing to go beyond noble bounds. 200,000 years ago, they would have died. Now, they don't. Now they have an opportunity to build something. But those people are fundamentally interesting, um, and they can be challenging, because that reality distortion field can also apply to you. So, I take what I said earlier. You say yes, you say all the things that you're supposed to say. They're still like, nah, I'm just going to move fast and break things. Or I'm going to, ask for forgiveness, not permission. Or I just believe that, yes, I'm breaking all these laws, but I'm sure that because what we're doing is so important and so good that people are just going to let me slide. I'm like, well, good luck with that. But you have to help manage these characters, and help them operate within this universe that they themselves are authoring and designing. And it's challenging. It's fun. It's exhilarating. It's cool to be a part of it. They're charismatic people in their own ways, quietly or loudly or something in between. But they are not normal. And you got to be ready for that if you're setting yourself up to be their legal counsel.
I think that's a good bridge to one of the things I wanted to talk about with you and how you feel about the type of instruments that allow gaps that you can't get bridged between the founder entrepreneur and the investor. So things like safes or earnouts, and I guess I'll let you say what they are, and how you feel about them, using them in practice.
Yeah. So, I think what's really interesting to me is that, and it's something I say to law students all the time, is that this is the practice of law, and this is true in any field, but the field I know best, which is startup and venture capital, hugely dynamic. When I started in 1996, it was pretty typical for a startup to raise its first ounce of money by selling common stock to friends and family. That almost never happens anymore. Um, Over time, the use of the convertible note entered the field, and then the convertible note evolved. Then there was a moment where people they moved away from Delaware C corporations. They were using LLCs a lot. There was a 10-year period where LLCs were very popular vehicles. We've moved away from that back to Delaware C corporations for good reasons. And then in 2013, you had the invention and the launch of the safe, which has fundamentally changed early stage financing transactions. 2013, I'd been practicing for 16, 17 years. And it was brand new, just a blast over the transom. So that happens and will continue to happen. The field changes and people innovate accordingly. I mean, I think to tell a long story very short, the classic venture capital investment vehicle is preferred stock. Founders get common stock, employees get common stock, advisors get common stock, investors get preferred stock. It's got certain beneficial and advantageous attributes and privileges and terms, not horrific, not catastrophic, or founders would never accept it. Founders accept it all the time. It provides some protection for the money, but it also helps the money get comfortable with making the investment. Those transactions, however, are very technical, and they have a lot of inputs and a lot of levers and a lot of knobs and dials, and they're expensive to consummate. So what do you do at the very early stage when you're raising money not in $10 million increments, but in $10,000 increments? And that's, as I mentioned, it was common stock. We moved away from that because too many early stage investors said, wait a minute, I've been hearing about this preferred stock. I think I want that. And we said, no, you don't want preferred stock. You're investing $10,000. It's going to cost us $20,000 just to do the paperwork.
Right.
So then we started to do convertible notes and safes, which are lighter. And they are convertible instruments that are basically just placeholders. Give me your $10,000, hang out for a while, and then when we actually do raise the big money in the form of preferred stock, you'll just roll in and convert your instrument as part of that financing. It developed because of a need and a gap in the market, and both have solved it very, very well.
And then the earnout comes in more at the exit, right?
Yes.
Where your entrepreneur is ready to sell or ready to join another company, fold his company into another company. And, there's a disagreement about, well, how much is this really worth? How much is it worth? And one guy's saying, well, look at my DCF, discounted cash flow. We're obviously worth, a cajillion 5 years from now. So I want my piece of that now. And the investor's saying, well, maybe. How do you feel about earnouts? Because I will tell you from my own, when I was a litigator, anytime I ended up in litigation over a deal especially with the founder entrepreneur, it was about the earnout. So I have a bit more jaundiced view of it probably than you might, but I don't know.
No, earnouts are terrible. I hate earnouts. I look at it this way: is that fundamentally what earnouts are trying to do is they're trying to bridge a disagreement on valuation. So as you described, the seller thinks their company is worth $100 million and the buyer thinks it's worth $80 million. Okay. When that happens in a venture capital transaction, when you have that gap of 100 million to 80 million, you've got to get alignment, because without an agreement on valuation, you can't calculate the price per share. And without calculating the price per share, you don't know how many shares of stock the investor is buying. So you literally cannot sell the stock, which you have to do if that's the way you're raising money, unless you agree on valuation. So it's hard. and it can be acrimonious and it can be stressful and intense, but you've got to find a way to get from 80 to 100 and find that place in the middle where both parties can agree, or maybe the deal doesn't get done. What happens in an M&A transaction is they say, okay, here's what we'll do. We've got this brilliant idea. It's something called an earnout. So seller, you think your company's worth $100 million. I think it's worth $80 million. I'll give you $80 million. But what I'll do is if the business performs well in accordance with certain criteria after the closing, then if it does well and it performs at the level that you think it's going to perform, then I would agree it probably was worth $100 million. So I'll give you that $20 million and you'll get what you bargained for. Sounds terrific. It sounds like this mastermind feature that individuals have cooked up in a lab someplace to solve an intractable problem. The problem is they just don't work because there are so many. First of all, the macroeconomic circumstances are always changing. You know, the insert tariff conversation here. Like you just don't know what's going to happen. Number one. Number two, and this is a profound issue. Seller is not going to control this asset after the closing. Buyer does. And buyer may decide to move away from it. They may not invest in it. They may not operate the business in the way that the seller would have wanted. When I represent sellers and they're looking at an earnout, I always say to them, do the deal if you're okay with $80 million. If you're okay with $80 million, then go ahead and do it and think about the earnout as gravy, cherry on top. Don't count on it. It's highly unlikely that you're going to see much, if any, of it. But if you're counting on it, if you have to have that, if $80 million is like, no, I would never accept $80 million, then you better have the hard conversation around valuation and just do it and see if you can get there. But that being said, and most deal lawyers would agree with me. You're not going to run into very many M&A lawyers that are going to say, oh, earnouts are wonderful. And they work so well, and I always advise my clients to use them. But yet they're ubiquitous. And it's
Yeah, and
because
most
business people
litigators
really
would
get
agree
addicted to
with
them.
both of us because, well, I guess other than the ones that enjoy billing the hours because the cases are massively acrimonious because the first thing that happens is on day two, the buyer does something different than the seller would have. And you go from your seller who is happy to get the 80 million or the seller who really wanted the 100 million and that's still the number in their head. They're angry from day two. You know, they're because anything that the buyer has done was obviously an attempt to, take money out of my pocket. That's obviously what they're doing. Instead of running their own business that your business is now a small part of.
Yep. Yep. 100%. No, I do not like them. And in fact, that was a piece of advice, going back to what we were discussing earlier in this episode. When I was a lawyer for all of 17 minutes, I was having a conversation with an M&A lawyer, and he brought me in to help him on a deal with earnouts. And he said, I have 3 words about earnouts: don't do it. And he's right. And I've not seen or observed or learned or experienced anything in the 30 years since to change my mind.
Great. So we've been going almost an hour and I think we've been going over an hour and haven't even mentioned what you do now. So why don't we talk, what do you do now? And why did you decide to leave private practice a second time?
Yep. So I'd be happy to talk about that. So I'm the chief legal officer of a company called Pacaso. Pacaso is in the property tech space. So when you hear companies introduced with that kind of nomenclature, the tech means that it's tech enabled or somehow leverages or uses tech to its advantage within its business model. And then the front end of the word describes the field or the area of the market in which they're operating. So if you're a fintech company, it's finance. Prop tech, it's property, it's real estate. So what we do is we buy luxury vacation homes, we fractionalize the ownership, we market and sell those shares to the public. It is a real estate type asset. It gives those individuals the right to use the home. That's what our technology does, is it operates the schedule and ensures equitable access. We also care for the home in a property management way on a going forward basis. We make sure the Wi-Fi works, repair the roof, those sorts of things. And then ultimately, if and when a owner needs to transfer out, they've had a life change, or they want to buy a bigger Pacaso, or whatever the situation is, we help them resell their share. So we operate on the front end, and in the center, and at the end. It is a very complex business. It's very transaction heavy and legal heavy. So first of all, we're operating in a world of real estate, which means you've got a lot of regulatory issues that you've got to navigate. You're also buying and selling real estate, which is an intense transaction. You're putting a whole set of owner documents and legal documents around that piece of real estate, explaining and delivering those documents to buyers. And it's a high ticket purchase for them. Our average per share price is $750,000. That's a lot of money. Um, then on a going forward basis, we're managing the real estate. Issues arise, legal issues and otherwise. And then, there's a legal transaction at the end when someone sells their share. That's a legal transaction. Also, other legal transactions, we're raising money. So we've raised about $230 million in venture capital. I was involved in that process. That was what gave us the fuel to grow. We've also raised around $1 billion in debt capital. That's what we use. It helps us finance the purchase of homes and to provide financing to buyers who don't want to pay cash, who want to buy their shares on credit. So we're able to provide that financing through the debt. Those are really meaningful and chewy legal transactions. And then we're right now in the process of a Regulation A offering, which under the Jobs Act is a way for companies like ours to sell shares in a quasi public type way. It permits general solicitation. It permits you to advertise. It allows you to reach out to traditional retail investors, giving those retail investors an opportunity to participate in a company like ours, which is not yet classically public within the SEC's nomenclature under the Securities Act. I've never done a Reg A offering before. Know a lot about them. Have worked with a lot of clients in my former life that thought about it, but it's becoming increasingly an interesting way for companies like ours to raise money, and we're taking advantage of it, and so far so good on that front. So you asked me why I made the leap. I just described one of the reasons why. This is a legally intensive business, and I knew that therefore consequently I would have a strategic role at the table. This is not the sort of business where legal is an afterthought. And I'm just there to do kind of day-to-day contracts. By the way, that's part of my job too, of course, but it's not the entirety of it. There's a lot of really interesting, highly stimulating legal activity that we're engaged in, some of which is very new in itself, is innovative and disruptive. I actually have a patent now, believe it or not, in terms of I'm a named inventor on a patent, which relates to our business model and the way that we've sort of legally developed and invented this product, which is kind of interesting. Not something I ever had on my bingo card. But also why I knew the co-founders from a prior life. I'd represented both in different capacities in the past, so they were a known quantity, and I had a ton of respect for the two of them, which also made sliding over an easy decision because I knew who they were and that they were people of character and integrity that I would be happy to work with and excited to work with. And then reason number three, I think I was just ready for a change. I'd been in private practice, with the exception of that interlude in the early aughts, for basically 25 years. I'd been at Thompson Hine for 17 years. I built a great practice, but I'd basically done everything there was to do in that particular seat. And I'm curious and want to remain stimulated, want to continue to grow. And this was an opportunity to do that, to move into a startup that I thought and still do think has got a lot of upside opportunity with a lot of interesting challenges and opportunities, and has been stretching me in lots of different ways. So that was reason number three.
Great. I only have one more question. Let me check in with Deborah to see if you had another.
I just have one last question, and thank you so much for joining us and taking time out of all you have going on to share your insights with students. My last question, what's the best piece of advice that you have ever received?
The best piece of advice that I have ever received. Well, I don't know if this was ever literally said to me, but how about I put it this way? The best piece of advice that I can give from a life of learning, which is play the long game. It's it's a it's a long life. I mean, let's putting aside health just, basic, stable, good fortune in that respect, which is not to be underestimated. I'm at a point in life where I've seen others who haven't been as so fortunate from a health perspective. So but put that aside. Let's just assume that you'll remain generally healthy over a period of time. Yeah, I graduated from law school 30 years ago. That's a lot of presidential administrations ago. There's a huge period of time between where you sit right now as a law student and where I sit right now. And I'm still not in the ground, God willing, and thank you. And I still think I've got some tread on the tires, and with more room to go and to grow. I spent a lot of time early in my career, very impatient, really trying to advance what the world was going to provide, the opportunities that would unfold naturally. I was trying to accelerate that process. And I think over the course of the first 10 years of my career, through an incredible amount of energy, stress, anxiety, work to advance and accelerate that process, I think I succeeded in accelerating it by about 87 minutes. So it's the point is, be patient, stay steady, stay in the seat, don't get reckless, play the long game, and the pieces fall into place. They will. And you'll end up in a spot 30 years hence that will feel like destiny. It'll feel like it was inevitable. It'll feel like it was always going to happen. Maybe that's true. Maybe it's not. But it's the way it feels. And it feels that way for everybody. So, I think it's a great career path. I think it's a career path that offers all kinds of options and opportunities. And so, I'm excited for students who are right at the cusp of that and getting ready to launch. And 30 years hence, hopefully I'm still around and I can see and learn and hear what they've discovered and what they've done and accomplished over that period of time.
That's great. Thank you, David.
It reminds me of a Philip Roth quote that I'll mangle, that history only looks inevitable when it's written on the page. But when it's happening, it's the relentless unforeseen.
Well said. I like it. Whether it's mangled or not, that's a good quote. You should just own it.
I'll just go. I'll say it. Well, if I mangled it enough, it's my quote instead of Philip Roth's, right?
That's right.
I have nothing else because you just answered my last question in answering her last question. So I just want to thank you for your time. I think it's been, I've enjoyed the episode, so hopefully everyone else will as well. And thanks again for your time.
Happy to do it.